case briefs, and so much more. LSData's got what you're looking for.
A 2000 case heard by the Minnesota Court of Appeals, Marriage of Chamberlain v. Chamberlain, highlighted the power of district courts in determining property division and spousal maintenance in divorce cases. After 20 years of marriage and 2 children together, Paul W. Chamberlain, an attorney, and Mary Lou Chamberlain, a second-grade teacher, decided to file for divorce. With combined assets totaling $900,000, the district court ordered the sale of their home and payment of unsecured debt from the proceeds. Mary Lou was awarded $2,400 monthly permanent spousal maintenance, which Paul appealed. The Court of Appeals upheld some district court rulings while reversing and remanding others. Notably, it determined that the appellant's premarital retirement plan contributions were indeed marital property and that the property division was fair. However, the $2,400 monthly spousal maintenance was deemed unjust and thus reversed. The respondent's attorney fees motion was also denied.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of climb.